Good morning, everyone. I call the Human Services, Finance and Policy Committee to order. Members, we have quorum present. I'll begin with the approval of the minutes. Chair Fisher moves the approval of March 17, 2026 minutes. Any discussion? Hearing none, all those in favor, please say aye. Aye. Opposed? The motion prevails. The minutes for March 17, 2026 are now approved. Members, we have a full agenda today. We'll keep this moving shortly. The first bill that we have is Chair Klevorn's bill. That is House File 3935. I move that House File 3935 be laid over for possible inclusion. With that, members, we have an A1 amendment. Chair Klevorn, do you want to explain the A1 amendment?
Yes, Mr. Chair. The A1 amendment does some important things based on conversations we've had with MDH, first responders, the providers, and elder advocates. The A1 now makes a response person-centered. We clarified emergency by saying that we were talking about medical emergencies. We've confined the bill to 5 common events that occur in assisted living, and we made notification to clients based on changes in policy. And another important thing is that we removed the fine, which was difficult.
Thank you so much for that explanation. Any member discussion on A1 amendment? Seeing none, all those in favor, please say aye. Aye. Opposed? The A1 amendment is now adopted. To your bill as amended, Chair Klevorn.
Thank you, Mr. Chair. I would just like to say that this bill is at the very heart of what it means to be a representative. A neighbor of mine called me to alert me of the fact that her father had died in an assisted living facility in the neighboring community. Larry, who was a 79-year-old, fell off of his electric scooter. His neck was pinned against the wall, and instead of receiving assistance from the attendants who were in the room, he slowly suffocated. Larry would have celebrated his 80th birthday last week. So this bill focuses on 2 things. It focuses on facility policy and procedure requirements, and it focuses on training requirements of unlicensed personnel. I've heard from numerous first responders that they spend a great deal of time responding to 911 calls to assisted living facilities for non-emergency and emergency events. And we have heard that in Illinois, Nebraska, and Wisconsin, they are also working to change this no lift, no touch policy. While the policy is well intended to protect the health and well-being of workers, it neglects the fact that individuals who are there may suffer grievous bodily harm when no injury could have resulted if they would have been assisted. So this is a very human-centered. It matches the consumer expectation that when a family member goes to assisted living, that there will in fact be assistance when they have a minor medical emergency, or it could be a major medical emergency as well. But they expect more than a 911 call and having their loved one laying on the floor while waiting for those responders to attend. And that is at the very heart of the bill. We're happy to answer any questions that you may have.
Thank you for introducing the bill. We have testifiers. Please, welcome to the committee. Please introduce yourself and proceed.
Okay. Christine Sundberg will come and testify if you'd like.
Ms. Sundberg, welcome to the committee, and please proceed with your testimony.
Okay. My constituent is on their way, but they've not yet arrived. So, but it's okay. Please go ahead.
Thank you, Chair and members of the committee. I'm Chris Sundberg from Elder Voice Advocates. Our advocate daughter, who is on her way here, got lost in our complex, so she'll be here shortly to tell her own story. But we've worked hard with the industry folks to try to accommodate their issues as well as the agency people, and I think we have a much improved bill. With that, I will turn it back over.
Thank you so much. And I do have Susie Scheller here, who is a lawyer who can answer technical questions if members have those as well.
Thank you so much. I know we have two testifiers who want to testify on this bill, the long-term care imperative team. Maybe we can pull an extra chair there.
You can stay. We'll just slide over.
Mr. Burnt and Ms. Hubert, please welcome to the committee and introduce yourself.
Thank you, Mr. Chair and members of the committee. My name is Kyle Burnt. I'm here today on behalf of the Long-Term Care Imperative. We appreciate the author's attention to resident safety. As you heard, we had an opportunity to meet with advocates on Friday to discuss the proposal, and we agree that residents should receive timely and appropriate responses during emergencies. And our providers take that responsibility seriously. The A1 amendment adopted by the committee does address some of our concerns. I think that that's fair to say, but it does raise some new ones. For example, the requirement of an on-site EMR, which is defined under 144E.27. I'm not an expert in that arena, but we are unsure if facilities would be able to meet this requirement, and we're not sure if the workforce exists to meet that. We will continue the conversations with advocates and the author as we try to understand a little bit of this redesign proposal. And I'll turn it over to my colleague to finish.
Ms. Hubert, welcome to the committee. Please introduce yourself and proceed.
Yes. Good morning, Mr. Chair, members of the committee. For the record, my name is Erin Hubert, and I'm also here on behalf of the Long-Term Care Imperative. And I think what I will just say is the event that brought this issue before the committee was a tragedy, and it certainly does not reflect what anyone wants to happen when loved ones are put in someone else's care. Beyond the proposal itself, it has served a really important role in reaffirming and establishing best practices in staff training and medical emergencies that may occur in assisted living communities. And both of our respective associations have been taking appropriate steps to reassert those best practices with our members. We also would like to thank Representative Klevorn for working with us, and we'll continue to do that moving forward. Thank you for the opportunity to testify.
Thank you so much for your testimony. Do we have anyone else in the public who wants to testify on this bill? We can move to member discussion. We'll give
That's okay.
your constituent the time when they're
Thank you.
Members, any discussion? Representative Barker.
Yeah, thank you, Chair, and thank you, Representative. So how will the department monitor that this policy is actually fulfilled?
Check Klevorn.
I mean, I should be more specific. What compliance will they have to do to make sure, compliance check that if this comes into law, that this is actually being followed?
Please introduce yourself and proceed with your testimony on that.
Yes, my name is Suzanne Scheller. I'm the legal advisor for Elder Voice Advocates, and I'm here just for some technical assistance on the bill. Chair Knorr, I apologize, I can't quite.
Represent background.
Representative,
fine.
thank you.
You can call me Baker.
We never call you back.
We'll call you by your appropriate name. Yes.
Michelle.
Representative Baker.
Backer.
Sorry, we'll get it right if I can.
See
But
what
in any
you've done
case,
there.
I see that. Okay. Sorry, Chair.
Thank you, Representative Barker. Michelle.
thank you, Chair Knorr, and Representative Backer. All right. So what we anticipate is because these provisions are in several different places in the assisted living statute, one is in the minimum requirements for an assisted living facility that's also in the training requirements and the policies and procedures. So 3 different places. What we anticipate is when there are the surveys by the Minnesota Department of Health, when they're looking at that, they would be looking at, are these policies and procedures in place? And so we would be anticipating it would be during those regular surveys that would be determined, particularly because of where they exist in the statute.
Okay. And thank you, Chair. Next question is what type of costs are we looking at for the assistant facilities and so forth?
Michelle.
Mr. Chair,
Chair Klevorn.
Thank you. I did do some research prior to coming here, and this recommendation came from first responders. It is a 40-hour requirement for individuals. It can easily be done online. It is advertised as do this in 1 week. The module costs about $895 and I only looked at providers that are listed on the Minnesota Department of Commerce website.
Representative Barker.
Okay, thank you. So another question. So are you saying what you're looking for? Because there's two ways to fulfill this model. And of course, I'm thinking of a assisted living not too far from where I'm at, which you could get someone to be an EMR, but that ambulance service, and it's not Browns Alley, but that ambulance service has trouble with EMRs and EMTs during the day already, okay? So, of course, one model would be that they would hire someone that's an EMR and be at the facility, or are you thinking about that one of the staff people would then be required to get EMR training?
Mr. Chair.
Madam Chair.
Thank you. Mr. Chair and Representative Backer, it is my understanding through talking with first responders currently that it could be a member of the staff that already works for the facility, so that additional staff would not need to be hired, but additional staff would need to be trained.
Representative Barker.
No further questions, thank you.
Representative Hicks.
Thank you so much, Chair. Thank you so much, Representative Klevorn, for bringing this bill. This might be a question for the imperative, but something that the tragic story that you told and that I saw in the media brought to my attention was, from my understanding, and someone can correct me if I'm wrong, but people are paying quite a bit of money to live in assisted living for more than just a 911 button. If the response to a minor emergency is a 911 button, I don't know why we're spending tons of personal dollars or taxpayer dollars in an assisted living. And so I was shocked because in the disability community, we do pick people up. That is what we do in 245D. And so I was not aware of this concern. So perhaps you or one of your testifiers could tell me how prominent, you said you spoke to first responders, how prominent is this problem? Because again, in the disability community, we assume that we will lift people if they fall down.
Chair Klevorn.
Thank you, Representative Hicks. I will say that it has been significant enough that the community of Maple Plain has in fact passed an ordinance saying that they will now start charging for these calls, especially when they're non-emergency. I believe what you're talking about is so important, and the reason I really wanted to carry this bill is the expectation of the general public is that when the word assisted living is used, that their family members will in fact receive assistance when something like a non-emergency fall occurs. And I will ask Ms. Scheller if she has more to say about this.
Ms. Scheller.
Yes, thank you, Chair Nor. Thank you, Representative Hicks, for the comment and question. I wanted to highlight two things relative to your question. One of the things the language in the bill is trying to do is distinguish that emergency from non-emergency, because no one disagrees that 911 and emergency services are appropriate in that emergency. But because the current status is to blanket both non-emergencies and emergencies under the no lift, no touch policy, we are asking for distinguishing between those two, having some basic training to address the emergency. No one is saying don't call 911, but we're also hearing that there is non-emergency situations in which someone could be assisted, and 911 might still be called. So it's really trying to address two things. To your question of the prevalence of it, I would say that as elder voice advocates, it's a frequent call. Quantifying the number of individuals that this affects is difficult, but it's rising to this level because there is an assumption or an expectation that when someone enters the facility, they would have some basic care, because that's really the number one reason they're going in there. Often family members are concerned of an emergency event happening at home where no one can see that. And so a big reason they're seeking entrance to the facility and admission is to be able to accommodate or address those situations when they occur, whether it's a non-emergency fall and needing just some assistance getting up, or it's an emergency situation that needs critical care. So one of the pieces of the bill is that notification requirement. We are saying people should be aware from a consumer transparency analysis. They should be aware as a prospective resident what the facility would be doing, what is the expectation. Because many of the contracts have provisions that allow proactively the facility to call 911 on behalf of the resident. So when they're seeing that language potentially in the contract, there is again an expectation that there would be some assistance in an emergency. So we're looking at that transparency piece as well in this bill. So thank you.
Representative Gand.
Thank you, Mr. Chair. In my former life, I served as mayor in East Grand Forks, and I know that our firefighters were pretty honored to go over to the assisted living facility and help lift residents. I would hope that, the outcome of this proposed legislation would somehow, we would triage and identify, is there an imminent emergency, right? Is there a risk of a worsening condition without quick lift, as you say, an obstructed airway or bleeding, various things. So I would hope that there would still be a provision where it would be very easy to bring those firefighters in. Again, they're honored. These are like their grandmas and grandpas, and they're honored to come over and help out and assist. So I hope this would not in any way preclude that from happening. Go ahead.
Chair Klevorn.
I agree with you 100%, right? We definitely want 911 called during an emergency situation, and therein lies the need for the training to help the staff, someone on duty 24/7 to be able to identify, is this non-emergency, is this emergency? I agree with you 100%.
Very good. Thank you, Mr. Chair.
The last one will be Representative Murphy, and then we have the testifier here.
Mr. Chair, the testifier,
Yep, after
thank you.
the question from, yeah.
Thank you, Mr. Chair. Thank you. My question has to do with just whether or not you've had conversations with assisted living providers, especially rural, with regard to the cost and the expectation of having 24-hour EMS services available. What were the conversations with them like?
Chair Klevorn.
Mr. Chair and Representative Murphy, your question is a very good one and one that has weighed on me heavily. And that's why it's so important that existing staff be trained, because we do know that recruiting new staff, retaining staff is a difficult situation. I also serve on higher ed, and it is something that I think we need to consider with the workforce. But understand, there is no free in this equation. Somebody is going to pay the price for the injury, right? So in this tragic event that has occurred with my constituent's family, they have paid a tremendous price, right? And in speaking with first responders, they tell me that this training is very simple to do. They have absolutely no concern that current staff can be easily trained. So it is weighing, the benefit, and the benefit is saving a life. It's really important. Thank you.
Mr. Chair, thank you. My biggest concern is making sure we don't drive providers out. We already give them lots of hurdles to get over. Let's not drive out providers, especially in rural Minnesota. We don't have that many options. And so we have to be really careful that we don't set up a system that really is hard for them to achieve, and so then they want to drop out. Thank you.
And may Ms. Scheller answer
Check
the
in.
question? Thank you.
Michelle, make it brief, and then we'll get to the testimony.
Thank you, Chair Noor. Thank you, Representative Murphy. I appreciate the comment. One of the things I did want to highlight is because of the nature of an assisted living, not having an RN on site 24/7, they're on call. That precipitates quite a bit of what you're seeing here. When you have that on call and you have a policy that says, call the supervisor, figure something out, the delay in that can be very costly for the resident. So good points, but I wanted to point out, if we had another staff person, like in the nursing home setting, typically there's an RN on site 24/7, but nights and weekends, it's an RN on call. That's a big distinction in the assisted living environment that precipitates the need for some training for basic emergency care. Thank you.
Good morning. Welcome to the committee. Please introduce yourself and proceed with your testimony. Please keep it brief.
Yes, thank you. My name's Adrienne Sloan, and my father, Larry Thompson, was at an assisted living where he unfortunately passed away due to the no-lift policy and to the individual, the aide that was on staff that came into the dining area where he was at when he was trying to safely get to his mobilized scooter. And he ultimately, while he was trying to redirect himself, because he did fall while he was trying to get on the scooter, try to redirect himself, ultimately fell into the wall with his head pinned between the wall and his scooter. And there was an individual that was there working in the dining area that just looked and did try to, he did leave the room, and from the looks of it, was trying to find somebody to render aid. And during the 3 minutes that he was still alive, there wasn't a 911 call. There was an aide that came in, but continued to argue with some kitchen staff as to what to do. He was still breathing at that time in that compromised position. Ultimately, she directed the staff to leave, and she proceeded to scroll in her phone to try to find a phone number to call rather than 911 immediately. And during that time, in the video surveillance, we could watch him breathe and then die. And the gentleman the sheriff who came on site originally, he arrived within probably 30 seconds. And EMT 30 seconds later. But my dad was left in that position, not breathing, for 7 minutes after the woman entered the room. And so I'm here today in encouragement of the bill that is being presented so that nobody has to go through this tragic death like I did. My dad was a Vietnam veteran, a very proud Marine Corps veteran. Thank you. Sorry.
Thank you so much for your testimony, and really sorry about the tragic incident. And I hope we can all find a good solution to address this issue. So thank you so much. With that, Chair Schumann.
Thank you, Mr. Chair and Representative Klevorn. Wondering on some of the changes that were made with the amendment there on the qualifications under 144E.27. Do registered nurses now qualify under that as they are now, or why the exchange there?
Chair Klevorn.
It is our understanding that they would.
Chair Schumann.
Thank you, Mr. Chair. With that, has there been any feedback from any of the other licensed professions that are a part of this? I know the recommendation came from EMS, and that makes sense that they would say, hey, get certified or get training like we get the training there. When I look at the National Registry of EMTs there's 20 board members there. Only one of them has a nursing background in that. And in this, we're asking for these other licensed types of nurses to get this EMT training. And so I'm just wondering if that's a larger conversation to have, or maybe you have been having that with other licensed care providers that are in the assisted living system now versus the EMTs.
Chair Klevorn.
Thank you. I believe the statement is not accurate, but I just want to verify that. I appreciate what you're bringing to I appreciate the concern you're bringing. Ms. Scheller?
Michelle.
Thank you, Chair Nort, Representative Schumacher. My understanding is that part of, again, the combination of the issues of not having an RN on site to make some of those decisions. So even regardless of training, I'm trying to get at the idea of the combination of circumstances warranting the request for the EMR training for someone on site. Because we're not asking them to be a licensed RN, the licensed RN may more quickly assess and determine do we need to call EMS, do we need to get the lift there? So I'm addressing the combination of circumstances that brings us to this point of saying if we're not going to have someone to be able to respond quickly with some assessment and training in that RN field, then we're asking someone to have some basic first aid to understand the emergency or to provide assistance in a non-emergency. So hopefully that answers some of your question.
Chair Schumacher.
Thank you, Mr. Chair. And so this would be for trained, unlicensed, and licensed staff equally, as long as there's not an RN on staff. It would be whether you have a medical license of some sort or certification. This would be in addition to that, as long as there wasn't an RN on site.
Chair Klevorn.
The requirement that we are looking for is to have someone 24/7 on staff who can determine emergency, non-emergency, lift, no lift, right? We want to prevent harm if someone should not be lifted, and we want to prevent harm if someone should be lifted. And you referenced EMT, and I just want to make sure that the body is clear. It's EMR. So this is like the base level training.
Chair Schumacher.
Thank you, Mr. Chair and Chair Klevorn for that. And we can talk offline about that. I just pulled that from the statute.
Perfect. Thank you.
From that, so whether it was a T or an R. Overall, and not in reference to this bill in particular, but just a general statement when we're talking about the difference between skilled nursing facilities and assisted livings and the transition from being able to live completely independently to the point where you need assistance around the clock. There needs to be transitions there, and I have concerns when we start to chip away at what the line between skilled nursing and assisted living overall. And again, that's not a comment on this bill in particular, but as with anything, we just kind of encroach into these other areas, and we talk about the expense of what it costs to be in an assisted living, and we continue to add other regulations, and it's all good-natured. It's all for the right purposes, but as we add on to that, the line between skilled nursing and assisted living gets more and more blurry, and that becomes just a problem, not for the type of care that's provided, but for the types of services that are available to the people in the state, especially at a time when we're getting older by the day. So thank you, Mr. Chair.
Thank you, Mr. Chair. For your closing remarks, Chair Klevorn.
Thank you very much. And I think it's the blurriness that we're trying to clarify. When families move their loved one into assisted living, they need to know exactly what the policies and procedures will be. There is a tremendous cost that individuals pay in situations that we heard from Ms. Sloan. There is no denying that. And to just have an individual on staff who is trained in basic first aid in the EMR program, and to be able to distinguish emergency, non-emergency, I think is a pretty low bar. And I think this entire bill is about raising awareness and protecting our Minnesotans. And so I appreciate your concerns about cost, but again, I will say that staff who are already employed can be trained. Maybe it will even elevate the workforce that would seek this certification, so that they would be more employable. I think that would be a great thing too for people in greater Minnesota, but really it is about preventing injury and preventing harm for Minnesotans, and I appreciate your support.
Thank you, Chair Klevorn, and to all the testifiers. With that, I renew the motion that House File 3935 as amended be laid over. So the bill is laid over. Members, we have House File 2216, Chair Moller. I move House File 2216 be laid over for possible inclusion. With that, I also see that we have a DE1. Chair Moore, welcome to the committee. We will proceed with the DE1 and then go to the introduction of the bill. If you wanted to walk us over what is in DE1.
I'm sorry, Mr. Chair, I couldn't hear. There was sound behind me.
The DE1. So we're moving, I move DE1. If you can explain what is in the DE1.
Yes, thank you, Mr. Chair and members. So the bill that was posted is a version of the bill that we had last year, and the bill that was introduced this year is actually 3622. So the DE is just putting that language into the bill that was here last year. And I'll just note there's one addition based on industry feedback from the bill as introduced this year at line 3.5 to 3.7, and that relates to the requirement that who can have access to the call logs. We just wanted to make it clear that it wasn't every single person could call and get that information, that it's just the family and others who would need that kind of access.
Any discussion on DE1 to put the bill in the shape the author wants? Seeing none, all those in favor, please say aye. Opposed? DE1 is now adopted. To your bill, Madam Chair.
Thank you, Mr. Chair and members. So this bill is a consumer protection bill, and it seeks to address several gaps in our assisted living statutes that have been identified by the Office of Long-Term Care Ombudsman, Advocates for Our Elders, and my constituents. The bill does four things. First, it requires that assisted living facilities have AEDs in each building on their campuses where residents live, and requires accompanying training. The provision is necessary because, as my constituents told me, in their facility, they refused the request to install one, claiming that since they weren't required by law to do so, they weren't going to do so. And there are several letters from my constituents about that in your packets. Second, it prohibits a facility from requiring a resident to obtain a guardian as a condition of admission or continued residence. These are decisions that should be made by the resident and their family, not an assisted living facility administrator. Third, it requires facilities to inform prospective residents of the latest health department survey results and any fines or corrective orders issued by MDH for the previous 3 years. And then finally, it requires the facility to keep a log of when residents call for help and how long it takes for that request to be answered. In addition to the constituents who approached me about the AED, another constituent of mine came forward recently to tell an extremely painful story about what happened to her mother-in-law in an assisted living facility. And members, she wrote a letter. Her name is Stephanie Johnson. I believe it was accidentally put into the Klevorn bill packet. So just would point you to that. But in the letter, as she explains, her mother-in-law passed away after living in an assisted living memory care unit 11 days after a fall. She had come home from the hospital and needed help getting to the bathroom, turned on her call light, and it was on for an hour and 41 minutes before anybody answered. And so she tried to get there on her own, and she ended up falling down. And her family members believed that that fall led to a rapid decline in her condition and ultimately her death. She passed away about 11 days after that. So in addition to that, she also explained to us when I talked to her on the phone about this that this was not the first issue that her family member had had with this particular facility, and she wished she had known their track record before signing a contract with them. And so that's why we put the portion in the bill related to them having to post that information or provide that information before a contract is signed. Finally, I want to acknowledge that we are in conversation with the long-term care imperative about the portions of the bill they have concerns, and we look forward to continuing their dialogue, the dialogue with them and engagement. And I do have a testifier, Mr. Chair.
Thank you, Madam Chair. The first testifier I have is Ms. Rudina. Please introduce yourself for the record and proceed.
Thank you, Chair Noor. Good morning, committee. Pariche Rudina with the Office of Ombudsman for Long-Term Care, here on behalf of the Consumer Advocates Coalition, and breathing irregularly this morning, apparently. Thank you, Representative Moller, for championing this bill, and thank you, Rep. Frederick, for co-authoring. Members, as Rep. Moller indicated, you have 4 letters in your packet from residents at an assisted living who thought they would receive life-saving measures, particularly through an automatic external defibrillator, or AED, when they moved into their new home. When residents realized no AED was available, they organized and attempted to work with their facility to get one, even offering to pay for the device themselves at one point. As the letters highlight, their assisted living facility declined to obtain an AED. There are AEDs in the Capitol complex, and state law requires schools to have AEDs, meaning those residents have a higher likelihood of surviving a health event here or at a grandchild's school event than at their home and assisted living facility. This bill ensures residents in nursing homes and assisted living facilities have access to this life-saving care. Residents and families frequently tell advocates that finding compliance information for an assisted living facility is difficult. HF 2216 addresses this issue by requiring assisted living facilities to provide this already public information to prospective residents. Relatedly, a call light response time log will help residents advocate for more responsive care and support enforcement efforts when a resident's request for help went unanswered for a long period of time, like an hour and 41 minutes. We also recognize that restrictive decision-making tools like guardianship should not be the first tool used to support a resident who needs this assistance. We are gratified to be working with the imperative on a compromise to meet our respective goal on this and other issues. For these reasons, we hope you'll support this bill. Thank you.
Thank you so much for your testimony. As you mentioned, the long-term care imperative. Please welcome to the table again, Ms. Hubert and Mr. Brandt. Please introduce yourselves again and proceed.
Mr. Chair, members of the committee, again, for the record, my name is Erin Hubert, and I'm here with the Long-Term Care Imperative. We, I think, agree with Representative Moller, the Ombudsman, and the advocates. We have been talking about the different provisions in the bill. I think we are optimistic that we will be able to find some common ground on a few of the items. With that, our concern around guardianship and conservatorship as drafted is that it could inadvertently prohibit a facility from appropriately seeking a guardian or a conservator if the resident or their family is not in a capacity to make decisions about their care or finances. And so we are hopeful that we can find a path that accomplishes the advocates' concerns as well as preserves that court-appointed process for our members if needed. We are opposed to Section 3, as has been previously mentioned. 144G.30 already allows residents and others to obtain a copy of any plan of correction of a facility, and surveys are publicly available through the Department of Health. We appreciate that the amendment adopted today clarifies who has access to potential audit logs and call information. Some facilities would be able to have some IT capacity to do this on a fairly automated basis, but it would be a fairly manual process for many others. And so we are going to continue talking about that provision as well. I think we understand where a lot of this is coming from residents, their families, and their advocates. And I think we are hopeful that we can find a path forward. We would offer some caution on these types of mandates, particularly when they don't come with a funding appropriation from the legislature, because then it effectively becomes a pass-through consumer tax to the residents themselves. And with that, I'll turn it over to my colleague.
Mr. Brandt, please introduce yourself and proceed with your testimony.
Thank you, Mr. Chair, members of the committee. Again, for the record, my name is Kyle Burnt. I am here today on behalf of the long-term care imperative. Appreciate the opportunity to testify. We can appreciate but are concerned about the provision which requires training and availability of AEDs. Many have seen these AEDs in public spaces where they can be used and protections for Good Samaritan use is protected. However, licensed facilities such as nursing facilities and assisted livings have different requirements and would apply the same protections to those publicly available, would have different ways to work there. This brings on significant training and risk that our operators are concerned about if they were used improperly. We are committed to the additional conversation with the advocates on this concept, but as I highlighted those concerns, as well with the CPR certification, in this it seems to be a orientation sort of language, but there's obviously a lot more to CPR than just an orientation. There's only a few groups that really offer the training, and that certification requires fees with certified instructors. With the turnover and recertifications, this would create a significant unfunded mandate. As Aaron had just talked about, some of those costs that gets passed on to those residents. While well-intended, we are concerned that these training requirements remove caregivers from the bedside while we are short some 12,500 caregivers in Minnesota. Thank you for the opportunity to testify.
Thank you so much for your testimony. With that, is there anyone else in the public who wants to testify on this bill? Seeing none, we now move to member discussion. I have Representative Barker.
Thank you, Chair. Chair Moller, it seems like this bill requires state review of certain price increases. And so my question is what criteria will the commissioner use to determine if those changes in prices are reasonable or excessive?
Chair Moller.
Thank you, Mr. Chair. I think, Representative Backer, you're looking at the bill that was noticed, not the DE1. The language you're referencing was in the bill that we heard last year. Portions of that bill got passed into law. The portion you're referring to did not, and we're not bringing that forward at this point. Yeah.
I was a little confused on that. Okay. And that's all I have then, because then I'm on a different page.
Representative Hicks.
So I love this. I know you're shocked that I love this, but I love it for a couple of reasons. So first, the AED thing, I am perplexed that that's not already required. And I know for me, we had AED training as part of our CPR in a 245D facility, even though in many of our homes, we didn't even have AEDs, but it was just part of our Red Cross CPR training to learn how to use them in case we needed to use them in community. So I guess I'm a little confused about why that's concerning, because I was, 20 years old and barely able to keep my life organized, and someone thought I could learn to use an AED. So I feel like we should be able to do that. That seems pretty bare minimum to me. As far as guardianship goes, guardianship is taking away someone's ability to make their own decisions and saying that another person gets to decide for them. It's a big deal. It should be a big deal. And it shouldn't be something that is required for them to be able to receive services, because there's a power imbalance there. And I know at this table I say this all the time and people just sort of are annoyed with me, and I get that. But there's a power imbalance when people need services and someone is holding a requirement above their head. Now, there are times when guardianship and conservatorship is absolutely appropriate. It happens. But we should not force it on people because it's good for businesses, because it's good for providers. I would remind you all again, for the 100th time this year, that we should listen to the people who are the consumers of the service first, and then the providers of the service second. Both of those things are equally important as far as how we make decisions, and they matter, but we cannot put the providers of the service above the people receiving the service. We have to listen to them and their families. And I feel like sometimes we lose that because we're so afraid of losing providers, because there's not an equal power balance, right? Like there just isn't. You need the services, and so you have to capitalism doesn't work when there's a short supply of the product. And that's sort of where we're at in senior centers and senior services and disability services. And so it is our responsibility as the legislature, when we're spending taxpayer dollars, Medicaid dollars, to help even that playing field so that the recipients of services and the taxpayers in Minnesota know they're paying for high-quality services. And I think forcing people to have someone else make their decision and take away their autonomy because it's financially preferable to providers is a slippery slope. And so I would like to make sure that we only do that when it's absolutely necessary. And I don't like forcing people to make decisions based on giving up their autonomy.
Chair Schumacher.
Thank you, Mr. Chair, and thank you, Representative Moller, for this. I think my thoughts haven't changed a whole lot from last year, particularly with the concerns.
We're hoping they did, Mr. Chair. Chair Schumacher.
Maybe someday. But the concerns on the guardianship is really just the question of what comes after that. If we put it into statute, do the providers go one step further and say, well, they may need guardianship at some point, so we're not even going to entertain providing services at this point? That's where the biggest concern comes from, and we've talked about that before with this. And then with the materials, just on the AED pieces of it, really just the cost is a part of it, and I understand how you weigh those things is difficult, but we do have, since last year, we do have rate caps that are put on for facilities to be able to buy things like this and to pay for the training for things like this. And with those rate caps, some of that would have to, that money would have to come from somewhere, and it's not coming from the state in order to do this. And so glad you're working with those who work in this every single day, and I would just ask you to continue to do that, and thank you, Mr. Chair.
Thank you, Mr. Chair. I just wanted to add a little bit on that. So knowing that it's not coming from the state, and it's our responsibility to make sure that we provide the equipment to the facilities. For example, we have the resource in the grant defines that we can give grants to assisted living program for that specific purpose, or even additional funding that we can provide, because the state is ultimately responsible for making sure that people are in compliance with the rules that we have and the laws that we put in the books. And hopefully we can come up with some plan to provide some of those facilities with necessary tools, such as AED and other tools that they need, because it helps. It saves lives. So I think we need to be thinking in how we can do that. I'll put it back to Chair Moller and Ms. Rudina.
Thank you, Mr. Chair, and thank you so much for the discussion. This truly is a consumer protection bill, and I know that my constituents aren't alone in these issues that they're facing, and so I just really thank you for your thoughtfulness and consideration as we move forward this session.
Thank you, Chair Moore. With that, I wanted to thank all the testifiers. I renew the motion that House File 2216 as amended to be laid over. The bill is laid over. So we're moving to House File 4354. Representative Frederick moves House File 4354 to be laid over for possible inclusion. With that, I see that you have an A7 amendment. Representative Frederick moves the A7 amendment. If you can briefly explain the A7 amendment.
Thank you, Mr. Chair. Just pulling it out now. The A7 amendment was not included in the original bill. It was something that was rolled around by DCT, whether or not that they were going to push this year. They chose to not include it. It was important to me to include it. And the story behind it is that we all know there's a lot of data that's available on state employees. Unfortunately, there is a specific case where in the Minnesota Sex Offender Program, clients there are requesting data on the staff. So if a staff has anything in their supervisory file, let's say that they were a day late or an hour late or missed a shift or something worse, whatever that is, that didn't result in termination, but there was some sort of anything that's in their supervisory file, the clients there are then going to those staff members of, I know this thing about you. Oh, you were late the other day. What was going on? And it's a manipulation. And so my amendment is geared towards putting some boundaries on those requests for data so it can't be used in a way, like a weaponized way against the staff there. That's my intention behind that amendment.
Any discussion on A7? Members' discussion? Hearing none, all those in favor, please say aye. Aye. Opposed? The A7 amendment is now adopted. So we will be taking the other amendments because this is all about agency policy bills. Those bills are being introduced, so we wanted to make sure that we provide the public and also members the hearing about those policy items. So we will proceed with the bill. Please address the underlying bill.
All right, thank you, Mr. Chair. I wasn't sure how we were going to do this. If we we're going to try to do all the amendments or not first. So the bill is, like I said, kind of the technical bill for DCT this year. It's still finding places in state statute that still reference DHS, so kind of making some of those updates. It ensures DCT can continue its standard healthcare operations by clarifying its ability to share limited patient data in narrow and specific circumstances. It allows the DCT medical director to authorize medical care in, again, limited circumstances. And it increases the amount of time an individual may voluntarily return to forensics program for a psychiatric or medical need. So right now, someone who might get provisionally discharged could come back for 60 days, looking to extend that for 90, just to make sure that they're supported and continue to be successful and something doesn't happen to result for them to need to come back for a longer term stay. And I mean, that's the nuts of my portion before we get to the massive amount of amendments.
All right, thank you so much, Representative Frederick. We move to the testifiers. Ms. Brianis, welcome to the committee. Please introduce yourself and proceed.
Good morning, Chair and members. My name is, for the record, my name is Carrie Briones. I'm the Legislative Director for Direct Care and Treatment. I will try to do a very high-level and relatively speedy walkthrough of the underlying bill for direct care and treatment. Sections 1, 2, and 7 are changes related to DCT separation from the Department of Human Services. Section 1 simply removes a reference to the DHS Commissioner and inserts a DCT Executive Board. No substantive changes. Section 2 allows for a designee in DCT to review data challenges for the MSOP sex offender program. This was a process that was in place when we were part of DHS. We would like to carry this over to direct care and treatment. It puts in a systems of checks and balances. We get about 3,000 data requests just on this item alone, and our DPCO cannot timely respond to those and review that information. So we'd like that change to come over with us. Section 7 creates new statute in the DCT chapter that allows for the conversion of employees from unclassified service to classified service with MMB approval. When DCT became its own agency, some positions were designated as unclassified under a special session law from 1997. When we went to go do a review of all the statutes that needed to change or be updated, the reviser and DCT staff, of course, did not find something that had not been codified into statute. So we are looking to hold our employees harmless. Just for context, Section 246C05, which passed by this body in 2023, provided employees transferring to DCT protections. Those protections expired as soon as we became our own state agency, so we would like to just make sure that we have the small pool of employees held harmless. Hopping over to sections 3, 4, and all of the changes in section 5 except for those under parens I, as Representative Frederick stated, this allows DCT to share information that was authorized under HIPAA as necessary for routine behavioral health care operations. In 2024, there was a change to the Minnesota Health Records Act that requires express authority under Minnesota law to share patient health information. Other healthcare providers get signed releases from patients and their guardians up front that allow for sharing of this information. For example, if you and I go to our clinic or we go into the hospital, we're signing those forms. Unfortunately, our patients cannot consent or do not have someone in place to consent, and this places DCT at a risk for losing, in the future, licensure, accreditations, our ability to bill insurance, Medicaid, Medicare. It would have impacts on general fund collections, and we could conceivably be required to scale back services, and knowing the high demand for beds, that's not a direction that we want to go in. So we'd like to get that fixed. Speaking to the additional change in Section 5 at Parents I, and this is at lines .9.13 to 9.23, this change allows DCT to disclose limited patient information directly to the guardianship courts for the purposes of supporting guardianship proceedings when a release of information cannot be reasonably obtained. DCT, specifically, this change would allow DCT to share information when a patient lacks capacity to provide consent or when a current guardian is unavailable, non-responsive, or refuses to authorize disclosure. This change would allow physician statements and relevant records to be submitted in defined circumstances to coordinate with appropriate decision-making authority. Sections 6 and 8 of the bill will allow the DCT medical director to authorize medical care in limited circumstances for patients that cannot consent to treatment, and good faith efforts have been made to locate a guardian, nearest proper relative, and anyone to authorize care on their behalf. This authority is specific to a single condition in medical treatment and is not a blanket authority. For context, currently, for non-emergency necessary care, such as treating infections or managing chronic conditions, DCT must seek consent from the nearest proper relative or obtain a court order authorizing specific treatment, and there are circumstances where that nearest proper relative cannot be located or is unavailable. This means that DCT must seek a court order for this routine care. The current process is inefficient and impractical, leaving patients without timely, routine, but necessary care for their condition until their condition deteriorates and becomes an emergency. DCT consulted with the Ombudsman's office and our partners to ensure guardrails and safeguards are in place so the patient can seek independent review of determinations and treatment decisions. And going to sections 9 and 10, this change allows an individual on provisional discharge to return to the secure facility longer than the 60 days currently authorized in statute. This change will allow for return for psychiatric needs for up to 90 days and for a medical condition up to 6 months. If the stay goes past the 90 days or 6 months for the specified condition, the provisional discharge is revoked and the individual will need to go back through the special review board process. That is a quick summary of the bill. And Chair and members, I have DCT staff here as if you have questions that I can't answer.
Thank you so much for your testimony. Any member discussion on the DCT? I have Representative Franson.
Thank you, Mr. Chair. Representative Fredericks, would you be able to tell us about 9.9 and through 9.12? Direct care and treatment is not required to share with federal law enforcement data on individuals collected, maintained, used, et cetera, et cetera. What kind of information are we not wanting to share with federal law enforcement?
Representative Frederick.
Thank you, Mr. Chair. Thank you, Representative Franson. We want to ensure that all of our state agencies are sharing data with the federal agencies as required by law. That happens. But we also want to make sure that they are not putting information out there, whether that's with the federal government or anyone else in the public, that they don't have access to. So I think that this is to clarify some of that, but I would let the department answer anything further.
Ms. Biranes.
Chair members, Representative Frederick is correct. This language is inserted to provide clarity that there's no change in what DCT is currently doing or the information it's sharing, but just providing clarity in statute that we will only share information as authorized under law.
Representative Franson.
Thank you, Mr. Chair. But can you give us examples of what should not be shared?
Ms. Biranes.
That's what I'm looking for.
Chair and members, I'd like to phone a friend from Direct Care and Treatment on this one.
Phoning a friend who wants to come to the testify table. Good morning. Please introduce yourself and proceed with the response.
Good morning. My name is Dale Klitsky, General Counsel for Direct Care and Treatment. Chair, Committee, the intent and purpose of that additional language was to be consistent with the Minnesota Healthcare Records Act. So when that change went forward, they took out the specific reference to federal, and so it said state. And so we were just trying to be consistent with that in climate. We would still share any information that would be required under federal law or state law with any authorities.
Representative Franson.
Thank you, Mr. Chair. But I'm still looking for some examples.
in some
Linsky.
examples in regards to,
What you don't want shared with
Representative
federal law
Franson.
enforcement. Sorry, Mr. Chair.
yeah,
Mr.
and I
Linsky.
think, when the initial went in there, it was just kind of comfort language. I don't, I know we've had discussions before, if that was something that necessarily needed to be in there. That was, but I don't have any direct examples of what we wouldn't share or couldn't share unless it's specified by state or federal law.
Representative Franson.
Thank you, Mr. Chair. So just out of curiosity, would it have anything to do with federal immigration issues, or am I jumping the gun here?
Representative Linsky. Mr. Linsky.
Yeah, Chair, Representative, there is certain requirements for DCT under federal law to share information with immigration law, specifically notifications under 631.50, especially, and additionally, if there was any kind of warrant, judicial warrant provided to DCT, of course, we would comply with those requirements.
Okay, thank you, Mr. Chair. Thank you.
Thank you, Chair Knorr. And I just want to talk really quick about the guardianship piece of things. So this would shift, I can't remember which section you were talking about, granting the medical decision-making authority over to the agency official. Does that, we just talked about vulnerable folks and guardianship issues in the last bill that we were just on. But now does this shift from a court-appointed guardian judicial review system to just like a universal, like a unilateral determination? Wonderful, thank you.
Mr. Chair, can I jump in real quick? Thank you, Mr. Chair. To address this concern, I just want to remind the committee that the programs that we're talking about in forensics, on the continuum of care, we're talking about people at the very end of that care. This is the final place that people would go, which often means that people don't have social supports, don't have family members, and the typical types of safety nets that we would hope all people have. So I just want to make sure that we keep that in mind as part of this conversation. Thank you.
I was hoping you'll share the ruler analogy, so please introduce yourself and proceed with the response.
Yes, thank you, Mr. Chair, members of the committee. My name is Dr. Kylie Ann Stevens. I am the Executive Medical Director at Direct Care and Treatment and a psychiatrist by training.
Proceed with the response, Dr. Stevens.
Certainly, thank you. So these proposed changes impact possible guardianship in two ways. The first is by allowing the DCT physicians to let the guardianship court know that someone may be in need of a guardian. So currently, without a signed release of information, we're unable to share that information with the courts. That is not standard of care for the community. If you go to the doctor and they think that your decision-making capacity is limited, then they have the ability to let the court know for your own safety and protection. That is not a right or an ability that the DCT physicians have now. So the first part would be to allow us to let the court know, hey, we've got some concerns here, would you please take a look? The second part related to medical decision-making capacity is in the case where there's no decision-making capacity available, where someone doesn't have the ability to consent to a treatment, where there's no guardian, there's no family members that we can rely on for making decisions in the situation that Representative Frederick just mentioned. In this case, we are unable to intervene if someone is unwell and continues to be unwell, and this would allow for, in the cases where there's no capacity, for the executive medical director, so myself at this point in time, but to review the case and approve non-emergency treatment. Currently, we're not able to do that until it becomes an emergency life or death situation, which is not in line with medical ethics and not what is best for the individual in care.
Vice Chair Gill.
Thank you, that helps.
Representative Barker.
Question I have is unintended consequences. You know, we deliver a lot of stuff through other agencies, and so would there be cost shifting to the counties with this?
Ms. Brianna.
Chair and members, there are no costs to any of the provisions in the bill.
It's purely policy bill, so we will not put any cost on this bill. Representative Barker.
Yeah, I think my question was taken way too literally, but when we're doing all this data and looking for, someone has to collect the data. I hear from the counties that, more and more is being put on their shoulders, which is, so I'm not talking about the fiscal note of this, but unintentional responsibility passed to the counties with this program.
Ms. Byrnes.
Chair and members, our understanding with the items before you is that there wouldn't be additional work shifting necessary to counties or an extensive data collection. It would be data that we would, for example, with the guardianship, that would be data we would provide under those court proceedings anyhow. We're not looking at a massively large number of, say, guardianship proceedings occurring as a result of this. So I don't believe that there would be.
Thank you. No further questions.
Thank you. With that, we now move to the A1 amendment. That is the OIG section. So, Ms. Didion, if you can come to the table. Thank you to the DCT team. Good morning. Please introduce yourself and proceed with I move A1 amendment, so please move with the introduction of the A1 amendment.
Thank you, Mr. Chair. Ari Didion, Legislative Director for OIG at DHS, and I will try to give as quick of an overview as I can of this kind of dense bill. So there's several changes, several no-cost changes related to background studies. The first set of changes are related to our background studies disqualifications. Staff routinely reviews Chapter 245C.15, the disqualifications statute for federal compliance, as well as reviews criminal code to make sure that Chapter 245C matches federal code and criminal code. So we have a few changes in here related to disqualifications. One of those is adding an order of protection for financial abuse of a vulnerable adult as a disqualification. We also add the new anti-kickback or illegal remuneration crime that you all are familiar with from last year that DHS proposed and was passed into law in 2025 session as a disqualification. It also adds back in 2024, interference with privacy at the gross misdemeanor level was removed, and we believe removing it at this level was unintentional, that it got caught up with other changes being made at that time. And then finally, in the disqualification package, there is a correction to statute for family child foster care background studies that 2 and 5 year disqualifications do not apply. Typically, our disqualification periods are 7, 10, 15 years or permanent. A few years back, there was a 5 years disqualification created related to some substance use disorder related crimes and drug related crimes to kind of offer some relief there. And so that is a shorter disqualification period. And also last year, we created a new background studies disqualification that was 2 years to address fraud, waste, and abuse. Family child foster care has a higher level of federal requirements, so this just clarifies that those disqualifications don't apply. The next background studies proposal relates to moving child and adult foster care and adult day services into our Net Study 2 background studies system. This system was implemented a number of years ago, and these are the kind of last remaining study types still hanging out in our legacy system, the Net Study not 2.0. And so this language just effectuates transferring those studies into the Net Study 2.0 system.
The next package out of the background studies area is a couple of cleanup and technical changes. One of these adds the term child foster residence settings to statute. This is already how these studies are set up in Net Study 2.0, so this just conforms statute with that practice and with that term. And then there's also a correction related to a variance that was created in, I believe it was 2024 session. The language being removed in this provision, it was problematic to implementing that variance process for foster residence settings and children's residential settings. And then the last one out of the background studies division is one related to federal compliance. There's two components. One of these is related to child foster care. Currently, law allows these studies to be transferable across all background study types. And this corrects that because the study types do not have similar federal requirements. And then the other portion is related to working under supervision when a background study is not processed. This just clarifies that for child care, study subjects cannot work while their study is in process, and that is to come into compliance with child care development block grant requirements that we need to have in place in order to keep getting FBI data for child care studies. And then the next set of packages are out of our licensing division. The first is a change of ownership definition alignment. This essentially closes a loophole in how change of ownership processes take place. Currently, there is not a change of ownership that takes place if at least one controlling individual on the license has been affiliated for the prior 12 months. We've found that this is allowing licenses to kind of change hands without us having full insight into who's responsible for programs. So this removes that loophole. The next one is a pretty simple kind of proposal, just removing the need for a standing order for certain programs to maintain a supply of opiate antagonists, such as Narcan. So this just essentially, since those are available over the counter, this removes that need for a standing order, just makes it easier for these programs, which are substance use disorder treatment, children's residential facilities, detoxification, withdrawal management, and IRTs, to stock those. And then the next one out of the licensing area is a bunch of cleanup changes. We're repealing DHS as the lead investigative agency for talking too fast. Repealing DHS as the lead investigative agency for psychiatric residential treatment facilities. This is already current practice, and this is something that is, MDH is the lead investigative agency for maltreatment investigations for these facilities already through an interagency agreement. So this just codifies that practice. There's a couple of changes in 245D to align Chapter 245D with the positive supports rule, as well as to clarify that residents' rights to live in a safe, non-hazardous setting is not a licensing requirement that can be waived. And then there's also a couple of cleanup items related to the licensing fees that were increased or modified last year. One of those was to the HCBS renewal fee. There was a couple of amounts where the language "or equal to" was missing, and so we don't want to miss out on the fee for revenue amounts for those exact amounts. Then there's also language adding a fee for the EIDBI provisional licensure, which was the intent of the proposal last year, but that language was not in place. And then there's language clarifying temporary immediate suspensions for licensing, We added new language last year, allowing us to issue a temporary immediate suspension, or a TIS as we call it, to address fraud, waste, and abuse. But we're finding that it was a little bit, conflicts with other language in that statute. And so this does a couple of things. It clarifies the burden of proof for DHS in issuing these TISs, and then it also makes sure that for this new TIS authority that passed last year, that we are able to, if there is an ongoing judicial proceeding or investigation, that we are able to move that into a regular suspension, which is something we can do for other TISs, but as statute is now, we can't do for that new TIS. And then the final technical change is just aligning the definition of related individuals in 245A with the definition used in the Community-Based Services Manual for Disability Waiver Services to allow folks who are related through marriage, for instances such as when someone is providing services to a spouse's relative in the home. And so this is just aligning that language with what we have elsewhere. And that is the licensing package. And then we have a few items from our program integrity oversight area. We have one package of returning and cleanup items. These items were either related to items that passed in 2025, or in the case of the first item, which is expanding our payment withhold authority under 245095. That was in the governor's fraud package last year. It was in both versions of the omnibus, but ultimately through conference and special session negotiations, that one didn't make it into the final bill. We really still think those are important provisions to allow us to stop payment if we have revoked or suspended a license, if there is a criminal conviction of fraud in another state or federal agency, or if there is a background studies disqualification for a controlling individual. And then the other items in this package are clarifying and cleanup. Language was added in Chapter 15, 15.013, related to state agencies' ability to stop payment. This language included a 60-day limit on those stop payments and the right to an appeal via contested case hearing, which is different than DHS's existing payment withhold authority. And so we have some concerns about this. So this language clarifies that DHS would not be subject to the 60-day limit or the appeal via a contested case hearing. We have concerns that 60 days is not long enough, given often when there is a payment withhold in place, there is a criminal referral, and 60 days is a shorter timeline than most law enforcement investigations, and then also a full contested case appeal could jeopardize ongoing criminal investigations, as the appeal process could make things relevant to the investigation available that wouldn't be otherwise. And that's kind of both on the provider end and on the agency end through that appeal. The next clarifying change is we have that new background study disqualification to address fraud, waste, and abuse. This is just updating the definition of excluded in 245095 to match that. There's also a clarification around prepayment review authority. We already have the authority to conduct prepayment review, but this language kind of tightens that up a bit, makes that clear that we have the authority to conduct pre- and post-payment review, and also provides that we can take actions related to that review. There is also a proposal that expands our authority to conduct site visits related to enrollment. Currently, we can't go on site if a provider has not yet billed, and so this gives us the ability to go on site once they're enrolled, since providers can be operating once they're enrolled and they have time to submit claims. So we think this authority is important. This was put in place last year for EIDBI, so this just extends that to the whole Medicaid program. The next proposal, this one is pretty simple but highly important. It's moving a definition of fraud from rule into 256B, where most Medicaid requirements and our corresponding program integrity statutes are. And so this puts that there. We can use this to refer more criminal cases based on as new crimes come online that fit this definition of fraud. And then finally, the last item is related to waiving notice to consumers when under investigation. Currently, to subpoena bank records, DHS is required to provide 180-day notice. And this is expensive and time-consuming. It holds up investigations. And so if accessing the financial information pursuant to a request by law enforcement would help protect the integrity of an investigation, we can waive that. And that is the OIG bill. Thank you.
Thank you so much for the testimony. That was lengthy, so we'll go to Vice Chair Gilman.
Thank you, Chair. My question is in regards to individual who is related on lines 4.18, 4.19, or down to 20. Just curious, is this found in other places in statute? It's adding a cousin, including an individual who has a relationship named in the subdivision through marriage. So you might hear around the Capitol, Senator John Hoffman's my cousin. And we are related through marriage, and I'm blessed because of that. But I just am curious, is this language found in other areas of our statute?
Ms. Didion.
Mr. Chair, Representative Gilman, I am not sure about if it's found elsewhere in statute. We took this definition from the CBSM, the Community-Based Services Manual, which is provider manual information for disability waiver services providers. And so we're just aligning with that definition.
Vice Chair Gilman.
Thank you. So my question as well then around that, that's where you're taking that. Wouldn't we want to align with an individual who's related in other areas? And maybe that's through nonpartisan or as well as we should ask. Does it, sometimes when I see things break off and there's different definitions in one area, is it better to have things align across the board? Otherwise we come back and visit about that. I'm not sure. I should ask.
We'll send it back to the agency. Ms. Didion.
Yeah, thank you, Mr. Chair. I can look into more information about how we reference that elsewhere in statute. I don't know offhand. But yeah, if it's not in alignment, we can certainly take a look at that.
Thank you.
All right, so the A1 amendment is before us. Members, this is just to put the language policy as a courtesy for the agency so that we have the language before us. This is not adopting a bill, so we will have more discussion because the timeline that we have right now doesn't allow us to cover all these bills. Any further discussion from members? Seeing none, thank you so much. All those in favor of adopting A1, please say aye. Opposed? The A1 amendment is now adopted. Moving to the next amendment before us is the A2 amendment. Ms. Savage, please come to the table to testify on the A2 and introduce. I move the A2 amendment.
Chair Knorr, members, my name is Gina Savage, and I am the Legislative Director for the Behavioral Health Administration at the Department of Human Services. I know we're short on time, so I will quickly walk through the bill and explain these proposed changes, but happy to answer any questions or provide more information if requested. Our Sections 1 and Section 26 are part of our Emergency Mental Health Services Statute cleanup. Section 1 clarifies that individuals who are receiving emergency behavioral health services Section 1 reintroduces language that we believe was unintentionally removed last session that makes it clear that individuals who receive emergency behavioral health services cannot be charged for those services. Section 26 also makes a clarification that for individuals who are Minnesota Care enrollees, they cannot be charged cost sharing when they receive mobile crisis services. Currently, the statute mentions crisis intervention and crisis assessment. Mobile crisis has 3 phases, so this isn't a change, just clarification that all 3 phases of mobile crisis are exempt from cost sharing. Section 2, 3, 4, and 7 are part of our alignment of the peer recovery support services definitions. Sections 2 and 3 are just updating some statutory references to point to the correct peer recovery support statute. And sections 4 and section 7 is a conforming change that removes language that limits supervision of recovery peers to alcohol and drug counselors only. Sections 5 and section 11 are related to our tobacco education proposal. Section 5, sections 5 and section 11 would do 3 things. This would require licensed SUD and mental health facilities to assess and document tobacco and nicotine use in diagnostic assessments. It would require mental health professionals to apply the tobacco use disorder diagnosis when the client meets those criteria. And then lastly, it would require treatment programs to provide tobacco education materials at the first day of service. Section 6 is a technical clarification. Last session, there was a change that changed the bachelor's degree for treatment coordination to a high school diploma. That language with the bachelor's degree was not removed, so this would just remove that bachelor's degree requirement, make it clear that that educational level is for a high school diploma. Our CTSS cleanup proposal, our Children's Therapeutic Services and Supports, also known as CTSS. This is sections 8, 21, and 22. This amends the CTSS statute to align with the licensing statute to require review of policies and procedures every 2 years. And then it also just cleans up some outdated terminology around the individual behavior plan in sections 8 and 21. Sections 9 and section 10 are our mental health professional affiliation and supervision limits. Section 9 would limit a mental health professional's affiliation to no more than 10 provider organizations and supervision to no more than 20 staff across all of those provider organizations. It would also establish an exception process for mental health professionals who can seek to affiliate with more than 10 providers or supervise more than that 20 staff and can demonstrate that they are able to do that without compromising quality of care. Sections 11, 12, 15, 19, 20, and 27 are part of our substance use disorder waiver cleanup. This removes outdated language, updates statutory references, and consolidates remaining waiver provisions. It also removes some outdated language and from the SUD waiver that refers to treatment placements, which became outdated after the implementation of direct access, and codifies a utilization management requirement for 10% of an SUD's provider's clients to be randomly reviewed, up to 10%. Section 14 is a clarification. This is not a change, but it just identifies that tribally licensed programs can deliver peer recovery support services. This is currently allowed by our state plan, but they are not listed in statute, which has created some confusion. Section 16 and Section 17 are adjusting the advanced care directive requirement. Currently, for mobile crisis teams, they are required to discuss an advanced care directive while the client is in a crisis intervention stage. That's not the best time to have some of these complex and difficult discussions. So according to federal best practices, we are moving that from the crisis intervention stage to the crisis stabilization phase of mobile crisis. Sections 18 and 23 are some just clarifications. It would Section 18 corrects a missed reference to this program previously was referred to as the Intensive Treatment in Foster Care Program. We are updating that language to correctly refer to the Children's Intensive Behavioral Health Services Program. And then Section 23 also allows temporary service reductions to be documented in the case file as well as the treatment plan. Sections 24 and 25 make some changes to our intensive rehabilitative mental health services, psychiatric care providers. I know Representative Gilman has a similar bill, so we're excited to be addressing the same issue. But this just aligns the requirements for advanced practice registered nurse and psychiatrist by removing that board-certified requirement, removing the child and adolescent requirement from board-certified. So this would align comparable standards for our advanced practice registered nurse and psychiatrists for medication management and clinical experience. And then lastly, this wasn't in the language, but it is in your summaries, but the Recovery Community Organization Certification Timeline. We currently, recovery community organizations are all required to be certified by June 2027. This proposal would advance that timeline forward by 1 year and require certification by June 2026. And I know that was fast, but happy to answer
Thank you
any
so
questions.
much for the bill. Vice Chair Gilman, member discussion.
Thank you, Chair. Really quick, when crafting this language for this bill, did you also visit with the advocates and folks that, we worked a lot with SUD, peer recovery services? I'm looking at lines 2.21. I can't remember when that was added in or taken, now you want to take this out, under the supervision of an alcohol and drug counselor. So now we're taking recovery peer qualifications, we're taking that out. Can you just tell me why that's being removed? I'm just curious.
Ms. Savage?
Chair Noor, Representative Gilman, can you give me the number of those lines again?
Vice Chair Gilman.
Lines 2.21 in section 4.
2.1, Chair.
Say that right.
Ms. Savage, that's the 2.21.
Yeah, Chair Noor, Representative Gilman. So in 2024, this, the Peer Recovery Support Services, they established a brand new statute. There was a new statutory framework. There was enhanced program standards. So this change, as part of that change in 2024, there was a requirement that peer recoveries could only be supervised by an alcohol and drug counselor, but the 2024 changes expanded that to allow mental health professionals to also do that supervision. So we're just striking this to align across all statutes and show that it's not limited to alcohol and drug counselors.
Okay. I just want to make
Vice
sure.
Chair Gilman.
Thank you so much. And in the future, like, just for the agencies to understand, this is great to get this today, but it's also really frustrating because a bunch of us have worked so hard on different areas in human services, and I'm frustrated today. We've asked for different things along the way, and just to even consult us as we've worked through different things, or just understanding what some of our folks in the community, even on the last bill, I want to put this on record. In the future, we are open and willing. I will stay after we are done with committees to go through some of these things. It's hard to get this a day or two before, when we've been asking for some of the policy work right from the beginning when we first got here. And we're getting it now, the week before. Thank you.
Representative Frederick.
Thank you, Mr. Chair. I want to echo what Representative Gilman just said, too. Like, her and I partnered a lot of this work regarding recovery community organizations and the SUD work in the SUD field. But what I can say is, even late last night, I was talking with people in the RCO space saying that they support the language in regarding the striking of the alcohol and drug counselor, and the change of the licensing piece from 2027 back saying even sooner, which is the framework that we as a legislature, but specifically Representative Gilman, you and I worked on. That we set that structure up. That structure is saying that it needs to be implemented even sooner. I take that as a compliment, saying we did good work. But I support that piece, but I agree with you that I would have loved to have a conversation about this before having the amendment drop. So I agree with you on that too.
Thank you.
Any further discussion? Thank you so much for the information. We will have more deep dive on all this language because we have little bit of time before anything moves forward, so we will be doing even extensive time if needed. So we're moving to the adoption of the A2 amendment. All those in favor, please say aye. Opposed? No. The A2 amendment is not adopted. To the final amendment that we have is A3 amendment. We-
Mr. Chair,
We will not be picking up the 4 and 5 because those bills, one bill is in health and then the other one has already been introduced. So if you can briefly explain the A3 and then we'll move to discussion.
sure. Mr. Chair, for the record, Christy Graham with the Department of Human Services. I will just, there was a summary that was sent. I don't know if members have that, but I'm happy to walk through the provisions in the Aging and Disability Services Policy Bill, which was Representative Gilman, to your point, which is well received, was discussed at large with the community, but happy to walk through these provisions. So the first changes are in Section 1. It's related to the corporate foster care moratorium. This is simply cleanup, removing expired and obsolete exceptions that are in that statute. There are changes in Sections 2 and 3 in the Home and Community-Based Services Positive Support Service area. These are technical corrections to correct a cross-reference that updates terminology in the statute. So a couple of sessions ago, there was licensure for behavior analysts passed, so it's updating terminology to reflect that licensure requirement. And then it's also, updating the reference to licensed professional clinical counselors. So technical only, no substantive changes in that provision either. Moving to the next bucket of provisions in Sections 4, 12, 13, and 14. These are related to early intensive developmental behavioral intervention. And they are making some updates on the changes, many of which were made by this legislature last session, just to clean things up a little bit and to make some clarification. So one of the changes adds EIDBI to the list of covered services. That's in the Medicaid chapter in 256B. That's just all of our services are listed there, and that was overlooked, so we are making sure to put it there. There's a change that's updating the definition of clinical supervision to conform with the federal requirements in our state plan. There's a change related to supervision, and which is referred to technically as observation and direction, to ensure that that's provided by a qualified supervising professional or level 1 providers. We want to make sure we've got higher level professionals supervising and providing that observation and direction. And then lastly, there are changes to require documentation for EIDBI providers. There is a licensure, a temporary licensure, provisional licensure that will be in effect later this year. But we don't have documentation requirements in the policy statute, so this is requiring certain things be documented in progress notes to ensure that there's medical, that people are eligible for the service, as well as documentation and personnel files about staff qualifications and training. Section 5 covers a change to tribes that are certifying their MnChoices assessors. So this gives tribes the ability to develop the experience qualifications to become a certified MnChoices assessor. So that's the assessment that authorizes people to be functionally eligible for waiver services and other long-term services and supports. There's a change in Section 6 related to MnChoices annual trend benchmark data. So there's a legislative report requirement in place for us to, I think it's to post a report now online related to 6 benchmark measures. However, last session, I think it was Representative Nadeau and then others in the other body worked on a more comprehensive change regarding MnChoices assessments and delays that we were seeing, as well as with the Hospital Association. So we now have a requirement to collect more comprehensive data around MnChoices assessments, what the delays are. We break that down by county and we publish it on a dashboard that's been implemented and available for you all to see. I was
been on it a few times, and it's nice to be able to click on Anoka County and see what their average wait time is for a min-choice assessment. So encourage you all to take a look at that. That came out of a lot of the good work from last session. Sections 7 through 11 and 40 are related to tribal, vulnerable adult and developmental disability case management. This is just making some changes that are recommended in a legislative report, which was published last May. I've got the link in a summary if you're interested in reading that, but this would allow tribes to determine eligibility and credential their own case managers. Similarly, we have another tribal sovereignty provision in section 15 that would basically put some parameters in place that align with federal requirements around informed choice for tribal nations, making sure that when people are dual citizens and they're working with a county, that the county is informing them properly and collaborating properly with their tribal nation that they are a citizen of, and that they have a choice to work directly with that tribal nation to get culturally specific and responsive services. There are some changes around DWRS and CFSS cost reporting, making sure that when we get reports from providers, in some cases we're getting them and they're incomplete, obviously incomplete, but we needed to sort of tighten up that language to make sure when that happens that we are able to reject that report and effectively say you need to submit the complete report in order to continue to be a provider and get payment in the system. There are changes around ICFDD, Intermediate Care Facility statute cleanup. So there are a bunch of old rate increases that are in law that we're deleting as a part of this. And then probably the substantive piece of this provision is updating statute to clarify inflationary updates so that they're based on what the 2023 legislature passed in terms of the base for the inflationary update. And then lastly, there is a lot of language that we've been working on since dating back to 2019 related to Vulnerable Adult Act. So this is related to a rule that was passed or promulgated. We've got till 2028 to comply, but we've been working with counties and advocates to get this language ready and in a place of agreement. So there's updating some definitions, clarifying rules for counties, overall making sure that we have a more uniform adult protective services system and requirements across the state. Right now, these services are administered at the county level, but there's a patchwork of outcomes, and there's a need for more consistency. I would add this is a no-cost policy provision, but I think the counties and DHS have been talking also for years about the need to fund them to be able to respond to the adult protective services reports that they're getting, and in some cases, they're having to screen out because they don't have the funds to investigate or look into those cases. That's the aging and disability services.
Thank you so much, Ms. Graham. I know for the interest of time, we're going to have an evening, hopefully we're requesting, so that we can have a long discussion on all these policy items. I will pull the A3 amendment, but members be prepared for an evening discussion. We will let you know when we're going to do the extended so we can also give the public more time to testify. In the interest of time, I will go back to the underlying bill and as amended to be laid over. So the bill will be laid over, but we will have more additional conversation in an evening session because we don't have all the time to go over all that. So with that, the bill is laid over. We will House File 4354 as amended is laid over for additional discussion at a different date. Representative Gill.
I guess I just wanted to say something on the record similar to what Vice Chair Gilman brought up. We all have election certificates here. Our community sends us to come do this job. The agencies are a different branch of government. And I have been saying this for my 6 years, and I think today is just kind of to the point of mass frustration. We as legislators come with extensive professional and personal background before we come and sit here politically. We work hard. We work hard across the aisle to find solutions that our constituents want us to come and do. And it is infuriating when an agency that both sides of this aisle just don't trust anymore. We don't trust that what you bring us is vetted. You've not worked alongside people who have spent their entire lives sitting at this table because we care about this work. It's not fair to our staff, both sides who spend a ton of time really diving into the unintended consequences that this could have a ripple effect into our communities. All of these amendments, there's not a legislator that's sitting in support of them. Why? Because the agencies they don't work with us. They don't work alongside us. We have solutions too. There are things that we could have worked really hard together. We have been saying this for a very, very, very long time. Many of us worked long hours over the summer when we were in the interim to try to find solutions. And when the agencies just hand us bills that we're supposed to carry for that, I just want to be clear, I am not a puppet to just carry legislation for an agency. I am here, and I believe many of you, to represent our constituencies, to challenge the agency to do what is best. That is why I chose to vote no on the amendments. I'm not saying that there's no good efforts in there, but when it's not vetted and we're not doing this work alongside the elected officials who are sent here to do this job, and I believe we have the skill set to do it, I think the agency needs to do better, and I think it's a lesson for us to move forward. We cannot end up in situations like this anymore. It is not good for Minnesotans. We hear every single day, lives are on the line. Every single testifier is a heartbreaking story. We deserve to be part of the solutions. This is not the way we should legislate in Minnesota. Thank you.
Members, I think this was a courtesy for the agency. These are not the language that comes from the members. It's the agency bills, policy bills. And if you know the deadline, it's on the 27th. We have 1 week to put together, a bill together. It doesn't mean that we're adopting everything that we're getting from the agency. It's to make sure that we have had the language, we have an opportunity to see what is before us, and we have done this in many times to make sure that we have the opportunity to go through this process, but also take a deep dive. At least for the interest of the public, they have seen the language that is being proposed. We need them to give us an input. We want the stakeholders to be engaged in that process. That is the main purpose of having this initial discussion. And then when we come back sometime next week, we can actually deliberate on what is going to be because it's the legislature that is going to be making that decision. And I appreciate the agencies coming forward because we asked them to do this. It's not their fault. The bills we have not been able to get the jackets for the bill. There's been a significant delay in getting the language in order for us to be on time. Otherwise, it means more overtime and to be able to do the same thing. So as I noted, we will have additional extended conversation. But I think we are running out of time at this moment. We have 2 other bills. I don't know if Chair Fisher wanted to run through quickly, but I think we can always come back next week as an added bill. I'm sorry to the testifiers who came a long way. We have more to do, and I apologize to anybody for the inconvenience, but we need to do this work in collaboration with the agencies and figure out what changes are needed. So with that, members, we are now adjourned.